Hi Cyber Class, it's Professor Opterbeck and welcome to week 3. This is a fully online week, and this week we are talking about personal security, stalking, and harassment in cyberspace. And let me note first that I know this is a bit of a difficult topic for many people. I'm guessing that at least some of you in our class probably have been subjected to some conduct that could be considered stalking or harassment, and cyber stalking and harassment. So these materials can be a little bit difficult, but it's important for us to discuss and to look at the law that applies to it, because it is such a widespread and pervasive area of cybercrime. And the first thing I want to ask you to do, if you started this video without having looked at the other video that I linked in the materials for this week, go on back and look at that other video first. That other video is it's a few years old now. Some of the references are a little bit outdated, but it's from a true crime sort of TV show, and it shows in a pretty frightening way, I think, how easy it is to cyber stalk somebody, and why, when we're dealing with really difficult personal conflict, or we're dealing with more organized attempts at extortion, or we're dealing with people who might be unstable, why this is a really difficult and important area. So if you haven't looked at it, stop this, go back and look at that first. If you have looked at it, go ahead and keep going. So when we're thinking about the legal issues for cyber stalking, cyber harassment, and we're going to look at the federal U.S. law statutes that cover this, there are two overarching legal issues we have to think about, particularly in U.S. law. But I think these overarching issues are also going to apply more broadly in the international space, and a little bit later in the semester when we start to look at law in the EU and we start to look at some of the international law issues. These themes will come back, and we'll see how different jurisdictions handle them differently, and how they potentially create some difficulties for how we think about international human rights. But here are those two big issues. The first one is the question of mens rea for cyber stalking crimes. And I mentioned last week this concept of mens rea and actus rea and mens rea in criminal law. We're going to circle back to that. I'll give you a little more information about what that means, and you'll see why this question of intent versus recklessness versus negligent is really important in this space, because going back to the material we looked at in the first week, you have this sort of ideal of someone like John Perry Barlow, of this open space of the free exchange and people's ability to express themselves in any way that they want. And in many ways we value that ideal, but we also recognize, all of you recognized in your discussion about it, the ways in which that fails to anticipate some things, and one of the things it anticipates is the problem that we're talking about this week. So how do you sort of balance an open space, a free expression kind of space, with the fact that certain speech is going to be offensive to certain people? Certain speech is going to be critical of certain people. And there's a zone of that where we might want to say, that might at times be unpleasant for some people, but that's what happens when you have an open space of expression. And in fact, sometimes the discomfort caused by free expression is what sort of pushes people to reconsider their views about certain things. On the other hand, when does that cross some kind of line into being something that we would call unethical or immoral, or at least something we'd want to make unlawful, which is harassment and stalking? And the mens rea question is going to come up there, the question of intent. And then, relatedly, questions of the First Amendment, of free speech values. Because a lot of what we're talking about, most of what we're talking about in cyberspace when we're dealing with these kind of crimes, involves speech. And therefore, a cyber stalking, a cyber harassment statute that criminalizes that conduct is going to be regulating speech. Now, it's a misconception that the First Amendment, that free speech principles mean you can't regulate speech at all. It doesn't mean that. What it means is that if you are going to regulate speech, there have to be really good, in fact, usually we say compelling reasons to regulate it. So I'm going to give you a little bit of information on the First Amendment in the U.S. and the way we interpret that as looking at when we can regulate speech or not. We're going to come back to civil rights, the Bill of Rights, later in the semester as well, in some other context, but we're going to begin to do that in this class. So let's look at our first federal statute that we're going to consider, which is the federal stalking statute. Notice that this is not the federal cyber stalking statute, but as we'll see, it covers cyber as well as other kinds of stalking. And like the Computer Fraud and Abuse Act, there are different subsections of the statute that have specific crimes within the general categories under the statute. So let's break down the elements of this statute. So in these first two subsections, we have a common theme, which is travel with intent to kill, injure, harass, intimidate, or place under surveillance with intent to kill, injure, harass, or intimidate another person. All right, same thing here, travel, place under surveillance with these intents, another person. Oops, that line's a little sloppy. And then we have certain kinds of conduct, with conduct that produces a reasonable fear of death or serious bodily injury, or with conduct that causes, attempts to cause, or would reasonably be expected to cause substantial emotional distress. So one of the huge questions in this statute is going to be, what is a reasonable fear of death or serious bodily injury? And then what is substantial emotional distress, and how does that differ from a reasonable fear of death or serious bodily injury? And then a related big question is going to be, is the focus here on the perception of the victim or alleged victim? So it is that person's reasonable fear and emotional distress that really defines whether there's a crime, or is the focus on the intent of the perpetrator, and therefore the question is it their intent to produce what would be a reasonable fear, or their intent to cause substantial emotional distress? That would be the trigger. And you'll see we'll look at some case law that's going to discuss that. The second two parts here also have similar elements. Use of mail or an electronic service. Use of mail or an electronic service. So this is covering traditional mails as well as cyber, with the intent to kill, injure, harass, intimidate, or place under surveillance with intent to kill, injure, harass, intimidate, causing reasonable fear of death or serious bodily injury. Same thing, use of mail or electronic service, place under surveillance with intent, kill, harass, intimidate, causing, attempting to cause, or would reasonably be expected to cause substantial emotional distress. So in these first two pieces, you have the act of travel and the act of surveillance. And in these second two pieces, you have the act of sending certain kinds of messages, either through the mails or electronically. So, let's say we have a celebrity singer who has a YouTube channel, and they post some kind of social commentary about one of their songs, and a troll in the comments says, "You're so stupid, I wish you would die." Well, is that a message that is with the intent to kill, injure, harass, or intimidate? Maybe. Is it a message that causes a reasonable fear of death or serious bodily injury? Maybe. Or maybe we would say someone in this position has to tolerate a certain amount of annoying and even maybe slightly scary trolling. Is it causing substantial emotional distress? Surely it causes maybe some emotional distress if the star notices it. Is it substantial emotional distress? Or again, what does that mean? Is this the kind of thing maybe somebody in that position has to learn to tolerate? These are the questions we're going to ask about the meaning of this statute. Now, this is kind of an overview of the federal stalking statute. In the next few slides that you'll see in the PowerPoint, which I'll give to you, it breaks down some of the additional details of each element of the crime. The travel part and all of this is going to relate to interstate commerce. As we have noted last week, interstate commerce is that element that allows federal law like this to regulate, to exist in the states. And the persons that could be the reasonable fear of death or serious bodily injury part is kind of interesting to look at, because it can apply to the specific person who is targeted. It can apply to an immediate family member of the person. It can apply to their spouse or intimate partner. So the threat doesn't necessarily only have to be against the specific person who's sort of the subject. It could be related also to their family, to a spouse or intimate partner. It also could be related to their pet, their service animal, emotional support animal, or a horse. I've always wondered over the years as I've taught this statute. I get this. I mean, pets and animals. I have 3 dogs. They're really important, and if someone threatened to kill my dogs, I'd be really upset. Horse, I don't quite understand. Not many of us own horses, but there you go. It's in the statute, and you can see a similar thing in other parts of the statute. Although cause substantial emotional distress parts of the statute don't include the pet or the horse. So I guess the statute is suggesting that, a pet or a horse could be the subject of, a threat of bodily injury or death, but it's not enough to simply make the I don't mean to laugh, I'm sorry, it's not enough to make the animal or the horse upset. We see the same thing in the parts of the statute that deal with transmitting threats, transmitting these kinds of threats, whether it is through... We see the same kind of thing with the transmission parts of the statute. Transmitting the threat of the fear of death or serious bodily injury applies to the family as well as to the animals, and the emotional distress applies only to the people, to the person and the family members. So I'm going to ask you a quick hypothetical under this part of this statute, and think about this for a second. Maybe pause the video. So let's say Abel meets Baker, and by the way, this, when we give hypotheticals in law classes, we often use, it's A and B, right? So A meets B, Abel meets Baker in a class, falls head over heels in love. Baker doesn't feel the same way, but Abel keeps showing up in the same place on campus and around town as Baker. At the coffee shop, restaurants, clubs, and the library, Abel's been able to do this because he's hacked Baker's phone and can follow Baker's GPS coordinates in real time. And that's really scary, but it's possible. Has Baker violated any provision of this statute, of the stalking statute? All right, so pause for a moment and think about this. If we come back, possibly Abel has been traveling and has been surveilling, right? So possibly the first parts of the statute have been violated, but here's the question. What is Abel's mens rea? Is Abel's intent to harass or intimidate? Or is Abel's intent to try and strike up a relationship with Baker? Was Baker placed in a reasonable fear of death or serious bodily injury, or substantial emotional distress? Now, who knows, right? Maybe in one sense we'd say possibly. There are lots of scenarios like this. it's starting to look like Abel is, moving beyond the kind of ordinary interest into some kind of obsession. Maybe we need more facts. Maybe we need to know if Abel has communicated with Baker at all, if Baker has made it clear that she's not interested or he's not interested. Not clear. And it's a typical scenario where it's difficult to know if the statute applies or if it should apply, if we want to make this criminal or if we don't want to make this criminal. Now, a related question we can ask, has Abel violated the CFAA? And this one should be easy for you. Yeah, right? I mean, Abel, we said, Abel has hacked Baker's phone. Abel has access to a protected computer of Baker's. The language I'm using here suggests, without authorization or in excess of authorization. So probably the malware and the access provisions have both been violated. So it's not that, Abel has done nothing criminal here. The question is, in addition to the CFAA violation, has Abel also violated the stalking statute? So the next statute that we're going to look at that is often applied at the federal level in cyber cases is the threat and extortion statute. And again, if you look at the overview of the statute, you'll see that it is not just a cyber statute. It applies to various kinds of threats and extortion, and that includes threats in the cyber domain. So let's look at some specific provisions of this statute. Transmit in interstate or foreign commerce, there's our commerce link, and again, anything on the internet is going to apply. Any communication containing any demand or request for a ransom or reward for the release of any kidnapped person. So notice that this presumes that someone has been physically kidnapped. The second part, or the second crime, again, general theme, specific crimes underneath. Transmit, interstate commerce, a communication containing a threat to kidnap or injure another person with intent to extort money or other thing of value. Notice that this is specific to an individual, to a person. This is not what we usually call ransomware, which is for data. This is for a person. Now, one thing you might want to think about here, money or other thing of value, one of the really unfortunate and difficult problems we have to deal with in cyber is sextortion, right? Which we would say is someone has intimate pictures of somebody. Maybe they obtained those intimate pictures initially legitimately, and now the person who has obtained those pictures is threatening to release them if the person who's the subject of those pictures doesn't do certain things, often stay in the relationship. Does that fall under this statute? The third part of the statute, transmit in interstate or foreign commerce a communication containing any threat to kidnap any person or any threat to injure a person. And then the fourth part of the statute, transmit communication containing a threat to injure the property or reputation of the addressee or of another, or the reputation of a deceased person, or a threat to accuse the addressee or any person of a crime with intent to extort money or other thing of value. So the sextortion kind of crime that we mentioned before, can that apply under this statute? Probably can, if we're dealing with reputation. And this is, if you look at it, a blackmail statute. So cyber blackmail, another common sort of crime that we're seeing, and a statute that could potentially address that kind of crime. So here's a hypothetical that I want you to think about under the extortion statute. And again, read the hypo, pause the video for just a second, think about it, see what you think. So Charlie and Delta, yeah, right, C and D, you could use A and B or C and D, are both in the waste disposal business. Charlie finds out Delta's having dinner with one of Charlie's longtime customers, Echo, E. Charlie sends Delta the following text that afternoon. If you interfere with my relationship with Echo, I'll crush you. Has Charlie violated any provision of the threats and stalking statute? Well, if we look at this hypothetical, maybe, but is this really a threat to injure Delta's person? Or is what Charlie actually saying that at a business level, in a competition level, I will crush your business, which can be perfectly legitimate expression of strong, even fierce business competition. How are we going to interpret that language? And this is why I ask, with this and our other hypothetical as well, what are your civil liberties concerns about charging Charlie? Remember that if the prosecutors bring a charge and they're able to get an indictment, then the full weight of the government is being brought against Charlie. Charlie's going to have to face trial. Charlie's going to have to, if he wants to be able to defend himself, obtain counsel. If Charlie loses, he might lose his business. He might go to jail. And that's an enormous weight. And do we really want to bring that weight to bear for language like this in the context of fierce business competition? We might also, again, need some more background and some more facts. I did give you this fact of it being the waste disposal business, which is a rough and tumble business, but is also a business historically that has had links to organized crime. So is the threat that Charlie's making actually more than a competitive threat? Is it a bigger threat of physical violence that actually has some credibility to it? We might need to know some more facts to actually determine this. Now, even if Charlie said, if you interfere with my relationship with Echo, I'll crush your business, even if Charlie made it clear this is not a physical threat, this is a business threat, there are still possibly some ways that you could shoehorn that kind of threat into the literal meaning of this statute. Now, I think, on civil liberties concerns and on criminalization concerns, this is not probably the kind of thing that we would want to criminalize. Now, maybe we'd like to, sort of as a matter of business ethics or something else, try to mitigate this kind of language or this kind of exchange. But the fact is, business competition is tough. Businesses like waste disposal can be highly competitive and rough and tumble. And, this kind of language is not necessarily out of bounds in that context. And so that's why we really have to consider what is the mens rea that we're really trying to get at? What's the bad intent that we're really trying to get at with these statutes? And how do they relate to the First Amendment? What is really speech that we don't want to even begin to bring into a criminal context, and what is speech that is getting outside of what we think is acceptable broadly for society that we might want to criminalize? So those questions from these hypotheticals we looked at lead into our discussion of actus reus and mens rea. And I talked about this a bit last week, but I want to give you a little more information about what we mean by these terms, and then we'll look at a U.S. Supreme Court case under one of these statutes that deals specifically with this issue. So under Anglo-American law, most crimes usually include both an actus reus and a mens rea. The actus reus is a voluntary action that society has some interest in preventing, or an omission to act where there's a legal duty to act. An involuntary action, usually speaking, cannot be a crime. We might have other forms of liability or insurance for certain kinds of involuntary actions, but they're not crimes. And this is why in Anglo-American law, we have a not guilty by reason of insanity defense. Insanity is a very outdated term, of course, but what we mean by that in modern law is that there's some kind of mental illness under which the person's action was not really voluntary. They weren't really in control of their actions. Mens rea is criminal intent, a guilty mind. So it's not enough that there's just a voluntary action. There must be criminal intent. In class last week, I used the example of, I throw a pencil across the room, and the pencil hits somebody in the classroom in the eye and causes them injury. Well, have I committed the crime of battery? And you have to ask some questions. Did I voluntarily throw the pencil? So let's say I'm of sound mind. Maybe some of you would debate that, but I'm of sound mind. I threw the pencil. Did I have criminal intent? Well, we have to look at the facts. Did somebody in the class say, "Hey, professor, can you throw me a pencil?" And I threw the pencil. Not criminal intent. I'm just intending to throw the pencil. Maybe I was negligent. Maybe I threw it too hard. Who knows, right? Or alternatively, we get into an argument about the nature of the First Amendment. I get very upset, and I angrily throw the pencil at you. Well, then we might say I have guilty mind. I'm intending to injure you by throwing the pencil at you. All right, so that's mens rea. Now, there are different possible levels of mens rea. These first two levels are the more typical kinds of mens rea that Anglo-American criminal law wants to deal with. The agent has acted purposefully, right? I purposefully threw the pencil at you, meaning to try to hit you someplace in the face, maybe to try to hit you in the eye to injure you. Acting knowingly, the defendant is practically certain the conduct will cause a result. I angrily threw the pencil toward your face. I wasn't necessarily thinking about hitting you in the eye or necessarily thinking that from 20 feet away I'd be able to hit you in the eye, but I was doing my best to hit you somewhere in the face where it's going to hurt. All right, practically certain. These other two pieces, reckless and negligent, Anglo-American criminal law wants to be very cautious about bringing into criminal mens rea. So reckless, disregarded a substantial and unjustified risk. Defendant, negligent, maybe not aware of the risk, but should have been aware of the risk. In other words, breached a duty of care. So I threw the pencil at you. I was really just intending to sort of throw it past your head and maybe just make a point or maybe just stop the argument. But in the context, perhaps there was a substantial and unjustified risk, because it's pretty hard to aim a pencil and my arm isn't that good anymore, that in fact I might, I'm trying to aim, a few inches away from your ear, but maybe in fact I could hit you. That might be reckless. Or perhaps you said, "Hey, throw me the pencil," and I flipped you the pencil like this. And I wasn't in any way intending to scare you or injure you, but I breached a duty of care. I should have reasonably known that there was a reasonable risk of the pencil going through your fingers and hitting you in the eye, perhaps. So this recklessness and negligence, usually we don't want to call a crime. Usually we want to say, if that happens, your remedy is to file a civil lawsuit, a negligence lawsuit, and to obtain money damages for your injuries, but no one's going to go to jail. The weight of the state is not going to be brought to it. But sometimes we might have a crime in a certain domain where we say, because of all of our other elements of criminalization, that we do want to make it criminal. I gave you the example last week of traffic crimes and then driving while intoxicated. And so driving while intoxicated is a traffic crime. If my intoxicated driving injures you, you have a tort, a negligence claim. But because of the nature of this problem, sometimes we do also want to make that a crime and more than just a traffic offense. Even if what I'm doing is not knowingly or purposely trying to injure you, but acting recklessly or even acting negligently. It depends on a lot of those other factors of criminalization. A final piece is strict liability. So strict liability, we'd say there's really no guilty state of mind at all. It doesn't have to be purpose, knowingful. It doesn't even have to be reckless or negligent. And another way of saying this is there are certain actions and certain things we simply want to consider contraband. You can't do that. You can't have it no matter what. Now, as you might imagine, this is going to be a really narrow category of things. And a classic example I note here, and which we're going to come back to next week, is the possession of child pornography. So the mere possession of child pornography, regardless of anything else, can be considered a crime simply because we consider that material that bad. And that's going to be a pretty narrow and rare category of crime. All right, now let's see how the question of mens rea relates to our harassment and stalking laws. And the issue is whether the federal transmission of threats statute that we just looked at requires the defendant to know that the communication was threatening, or does it only focus on what the victim reasonably thought was the communication? So remember that when we're looking at case law, this is the first thing we want to do. We want to try to identify the issue. And this is how I would state the issue in Alonis. Remember also that when we're looking at a case, it can be helpful sometimes to set out procedurally how we got there. So what's the procedural history in the Alonis case? So Alonis is indicted under the threat statute we just looked at. He moves to dismiss the indictment. So remember that I said last week in U.S. federal criminal law, the U.S. attorney goes to a grand jury, brings an indictment. The grand jury says, okay, there's enough evidence that you've presented to us that we believe there's grounds for this case going to court. And then the indictment gets filed with the court. And then the defendant has an opportunity, if the defendant wants to file a motion to dismiss the indictment for any number of reasons. And it could be the defendant says, you know, notwithstanding what the grand jury allowing it, the facts don't support the crime. Or very often on constitutional grounds, saying some aspect of the statute under which the person has been charged is unconstitutional. And so Alonis is moving to dismiss the indictment on the ground that the threat statute as applied to him in this case is unconstitutional. That motion is denied, so that means the case is going to go to trial, and the case does go to trial. And remember how I mentioned that when a case like this goes to trial, the judge is going to give instructions to the jury about what the law is. Then the jury is going to make a decision. If the jury finds the defendant guilty, the defendant has a right to appeal to the intermediate courts, and very often some aspect of that appeal is going to be the judge's instructions to the jury were incorrect as a matter of interpreting the statute or applied the statute in a way that is unconstitutional. So the instructions that the judge gives focus on the victim and say that the element of threat, what constitutes a threat under the statute, is something that a reasonable person, a reasonable victim, right, would construe the statement as threats. So the focus is not in these instructions on what the defendant, Alonis, had in his mind, what he thought he was transmitting. So Alonis is convicted, and he files a petition for certiorari, which the Supreme Court takes. And remember, that means the Supreme Court thinks that this is an important enough question that the Supreme Court ought to weigh in on the issue. And Alonis is arguing, the defendant is arguing, the focus ought to be on the mind of the defendant, not on the perception of the victim under this statute. So we want to, in briefing our case, look at the facts of the case. And, unfortunately, the facts of this case portray a typical kind of instance of cyber harassment or cyber threat or cyber stalking. A relationship that goes bad, the other parts of the person's life sort of beginning to go downhill. He begins to make angry posts on his Facebook page about his wife and his law enforcement officers. Now his claim, and you can read some of the material that he posted in the case, and his claim is, look, my intent was not to actually scare or threaten my ex-wife. My intent was, I'm a rapper, and rap lyrics are sometimes over the top, are ways of expressing big emotions. This is part of the genre of rap. And that's all I was intending to do, not to commit some kind of crime. All right. So what does the court hold? We want to, remember in the next part of our briefing, a case trying to determine not just what the court concluded, affirm, not affirm, but why. And the majority of the court says the mens rea element of the threat statute is the defendant's knowledge that they are transmitting a threat, not the perception of the person hearing the threat. So the focus of mens rea, the Supreme Court says, has to be on what is in the defendant's mind, not the perception of the victim. Now I know, I'm guessing, a lot of you hearing this are saying, wait, there's something wrong with this. Shouldn't we be focusing on the victim? Isn't really the main purpose of this kind of statute to try and protect the victim? And I think that's an incredibly fair point and a necessary point. But this is a place where this kind of law, this kind of criminal law, kind of butts up against our concepts of criminalization, of when something should be a crime. Should the compensation to the victim be potentially in a civil lawsuit for, intentional harassment or for some other tortious conduct where some damages could be recovered, or should it be criminal? Or also, should the remedy of the victim be potentially in the family courts, where you might be able to get a restraining order, rather than in the criminal courts? And part of what you're going to do in your discussion board is have some discussion about these things. And I know one of the things that some people will bring up, and rightly so, those remedies on the civil side are pretty thin. A person like Alonis probably doesn't have any money, so you might get a judgment against him, but you're not going to collect any money, right? And in the family courts, you might be able to get a protective order, but they're very hard to enforce. There are many, many tragic cases of people getting multiple protective orders and then being, ultimately injured or killed by the person against whom they have a protective order because they don't get enforced. Yeah, I mean, these are huge systemic problems, and they create real difficulties for the law. So Justice Roberts, writing for the majority of the court, and his reasoning is all about what mens rea usually means in a criminal statute, right? Must be conscious. Mens rea usually means that intentional kind of conduct by the defendant. He notes, Justice Roberts does note, that sometimes a criminal statute will encompass mere negligence. And if this statute were read to encompass mere negligence, then it could be that Alonis was properly convicted. But what Justice Roberts is suggesting here is that if a criminal statute is going to cover mere negligence, it should be absolutely clear that that's what it's doing. And this goes back to our discussion of criminalization and the idea of clarity and drafting and the rule of lenity. The ordinary assumption is mens rea is intent. If we're going to go beyond that ordinary assumption, then that has to be really, really clear in the statute, and Roberts did not see that clearly in this statute. And so he holds that the intent to transmit a threat, so the specific intent, I want to threaten this person, or knowledge that the communication will be viewed as a threat. I'm transmitting this. I don't really mean to follow up on what I'm saying here, but I know that this person is going to perceive that I very well may follow up. And that's different from simply saying, well, I'm transmitting something, I have no intention for it to be a threat, I don't really know this person is going to perceive it as a threat, but if I stepped back a little, I could have, the person who's receiving it could reasonably have perceived it as a threat, which would be mere negligence. Notice that the court does not decide whether recklessness is enough. The court says mere negligence is not enough. Merely that the person receiving it would reasonably perceive it as a threat is not enough. Obviously, the court says intent to transmit the threat, or intent to transmit something knowing that it would be perceived as a threat is enough. Would transmitting something where it is highly probable under the circumstances that it would be perceived as a threat be enough? That would be recklessness. Court doesn't say, so it leaves that question open. In a concurring opinion, Justice Alito makes clear that he thinks that recklessness would be enough, and he thinks the court should have decided that issue and clarified this question at that point. We talked a little bit last week about majority opinion and dissenting opinion. It's also not uncommon for there to be concurring opinions. So what does that mean? It means Justice Alito votes with the majority. He agrees with Justice Roberts and the other justices in the majority that this conviction should be thrown out and the case has to be retried with different instructions to the jury. But he also thinks that something more should have been said by the majority. Now, in a concurring opinion like this, what the justice writing the concurring opinion says is not the law. What the justices in the majority opinion say is going to be the law. But this is sort of staking out a position, possibly for a future case, when this question of recklessness may come back to the Supreme Court. We have a dissenting opinion by Justice Thomas, and Justice Thomas's main concern is that he thinks the opinion of the majority is simply not clear enough, and he thinks this is particularly a problem in a statute that relates to speech. Now, as we read this case, when we read this facts, I'm curious to see in the discussion board how your perception of aloneness is, and whether you have any sympathy at all for sort of the speech-related argument that, hey, the guy's a rapper. There are lots of rappers who say lots of nasty things, but that's part of the performativity of rap. We may not like it. Some of us may not like it, but it's just part of rap. My guess is many of us don't feel that way about him. I don't feel that way about him. I mean, it seems obvious to me that this is pretextual and that he's just trying to make his ex-wife's life miserable. And maybe Justice Thomas recognized that too, but what he's trying to sort of stake out a little bit is there are going to be future cases that are going to be more ambiguous. And what do we do about that? We need some guidance. So the aloneness case gives us something to chew on regarding mens rea and threat, stalking, harassment kind of statutes. Let's also talk about the First Amendment issue, which is related in some ways to that mens rea question. So here's what the First Amendment says. We're going to come back a little bit later in the semester and talk more specifically about the Bill of Rights and how they came about. Just know for now this is a foundational part of the American constitutional order. So the first part of the First Amendment are the religion clauses. We will come back to talking about those. And we have clauses relating to the press, clauses relating to the right of assembly, clause relating to the right to petition the government. But the one we're going to focus on is this clause, abridging the freedom of speech. So Congress shall make no law abridging the freedom of speech. Now, if you took this strictly literally, you might say these threat statutes we've been looking at are facially unconstitutional. Certainly, the threat statute, which criminalizes making of threats under certain circumstances, abridges the freedom of speech. It says, hey, you can't say that under these circumstances. You'll be convicted of a crime. All of which shows that even when the language kind of seems absolute like this, we have some interpretation to do. We have to figure out what is this really meant to say? Is it really meant to be absolutist like this? And it's not. So a few general principles about the way the Supreme Court has interpreted over the years the meaning of that Congress shall make no law abridging the freedom of speech. And I'm going to kind of scroll down and then we'll come back to this. So we have two possible kinds of restrictions: content-based restrictions, time, place, and manner restrictions. So a content-based restriction is a restriction specifically on the speech itself. A time, place, and manner restriction is not restricting the speech itself, but is putting limits on when or where or how it can be said. So if we look at this for a moment, if a city has a law that says if you are going to protest a government policy, you're allowed to protest, but there's a space within a proximity to the state house or the courthouse where you can do that protest. There are certain hours of the day or night when you're allowed to do that protest. That's a time, place, and manner restriction. If the government says you may not protest the governor, right? That would be a content-based restriction. Or more to the point of our example, you may not transmit a threat. That's a content-based restriction. So time, place, and manner restrictions are viewed more generously under the First Amendment. Content-based restrictions are viewed more strictly. So if we're looking at a content-based restriction, the Supreme Court is going to apply something called strict scrutiny in U.S. constitutional doctrine. What does strict scrutiny mean? It doesn't mean it's sort of per se out. You still can, the government still can enact content-based restrictions, but they're very hard to enact because they have to pass strict scrutiny. So we need a compelling government interest. This is the highest constitutional test of a government interest. It has to be narrowly tailored to that interest. So the actual regulation has to very closely track what that compelling interest is, and it has to be the least restrictive means to achieve the interest. If there's another way of achieving that government interest that places less restriction on speech, then the government has to adopt that less restrictive means, and the statute as enacted would be unconstitutional, or as applied in some situation would be unconstitutional. For a time, place, and manner restriction, it's a different level of scrutiny. It's a lesser level than strict scrutiny. So first of all, the restriction must be content neutral. So in my example of protests, really the city law ought to say you may speak publicly on any topic you want, outside of the State House or outside of the courthouse, whether it's a protest, whether it's applauding, whether it's advocating for a new piece of legislation, whatever it is, that's content neutral. All right. It must be narrowly tailored and to a significant government interest. So significant government interest versus a compelling government interest. Compelling is the highest level of government interest. Significant is important, but it's a lower level of government interest. And it must leave open ample alternative channels for communication. So compare that to the least restrictive means. So least restrictive, you have to have a really close fit, a very tight fit. Open ample alternatives doesn't have to be the least restrictive. I mean, you could sort of make the zone where you're allowed to speak publicly outside of the State House, 100 yards away from the steps. Possibly you could have made it 50 yards away from the steps. Maybe that would be less restrictive. But, as long as under time, place, or manner restriction, you can speak there. You have other ways you can speak too. You can march around the block. You can put a post on the internet. Lots of different ways you can communicate. So you can see that that is a much lower standard. So we are dealing here off the bat with content-based restrictions, so we're going to apply strict scrutiny. Noting this, however, there are some categories of speech that over the years the Supreme Court has said are not protected by the First Amendment. Or a better way to say this is that this strict scrutiny test, is generally passed with respect to these categories of speech. And here are those categories. Obscenity. Now you might be shocked to see that category. Wait a minute. Under the U.S. First Amendment, governments can criminalize obscenity. Yes, they can. The question is, what is obscenity? And there is an enormous amount of case law talking about that. We're going to come back to that when we talk about child pornography. Defamation, and so defamatory statements are statements that are untrue and that cause significant reputational harm. Fraud, we talked a little bit about fraud last week. Speech integral to criminal conduct. So this is getting at people who are conspiring to commit crimes, for example. So, the underworld criminal bosses are meeting in a smoke-filled room to plot the murder of a politician who is opposing them. They're speaking, right? But that act of conspiring can still be a crime because that is integral to the murder. And then, and this is really the category that we're going to be looking at, is true threats. So speech that is threatening harm and violence is not protected under U.S. law by the First Amendment. The question is going to be, is it a true threat? And there's, again, a lot of case law trying to define what is a true threat versus language that might sound or seem threatening, but that is otherwise protected by free speech. And I hope you can see from this how these principles loop back into that question of mens rea that we saw in the alonus case. Because the question of mens rea, what's the intent of alonus, as opposed to what is the perception of the victim, is another way of getting at the question of, is this a true threat or is it something else? So we're going to look at a couple of cases under the First Amendment involving whether these statutes we've been looking at are valid under the Constitution. And the first one is U.S. v. Sayer. This is the First Circuit, so this is an intermediate appellate court. This is binding on all of the states within the First Circuit, including, for example, Massachusetts and Connecticut. It's not a Supreme Court case. All right, so the issue. Does the cyberstalking statute we have looked at violate the First Amendment either as applied to the defendant or because of facial overbreadth. So to understand this, you have to have another little bit of sort of inside U.S. lawyer baseball about the First Amendment and about constitutional challenges. There are two kinds of constitutional challenges to a statute. First, we can say the statute as a whole, in relation to the First Amendment, is facially overbroad. It simply can't be construed to be consistent with the First Amendment, and therefore the whole statute has to be tossed. That's a very big challenge, and it's harder for the challenger to make. More narrowly, you could say the statute as a whole might be okay, but in this particular instance, as applied to this defendant, the statute unduly impinges on speech. And so at least in this case, and in cases like it, we'd have to say the statute is unconstitutional, and that's a more narrow challenge. So procedural history in the Sayer case. Sayer's indicted for cyberstalking under the statute we've been looking at. He moves to dismiss the indictment. That goes up on appeal. Meanwhile, he pleads guilty. Now, procedurally, it's possible for him to continue, have a sort of conditional plea that he's pleading guilty, but it allows him to continue this appeal, and if the appeal is eventually granted, then that guilty plea is vacated. So the facts of the case. Well, we have again one of these unfortunate but common kinds of cyberstalking. They've been in a relationship, they broke up, Sayer is obviously unhinged, he's physically stalking her for multiple years, and he's engaging in kinds of revenge porn, and another really unfortunately common activity, which is posting fake ads for sex, which are causing men to show up at this woman's house. You can see this case, dating from a number of years ago, using a space like MySpace. You could say today Facebook, you could say Instagram, or you could say other sites where he's posting revenge porn. And he continues doing this for a long period of time. So what does the First Circuit hold? And the First Circuit's holding here is that the cyber stalking statute, or this stalking statute, does not violate the First Amendment, either facially or as applied as to Sayer. And what is the court's reasoning? How does the court analyze this? Well, facially, the court notes the principles we've just been looking at, which is the First Amendment does not absolutely immunize speech. There are categories of speech that, under that compelling interest test, that strict scrutiny test, can be criminalized. And the statute is not overly broad. It does focus on a specific mens rea, a specific kind of intent, which means it's not overly broad. And then as applied to Sayer, Sayer admits to conduct. I mean, this isn't even a case where there's any question about Sayer being a rapper or something like that. His conduct of sending men to his ex-wife's house for sex is an admission enough to show that as applied to him, it was narrow enough. So the First Circuit upholds the statute under the First Amendment under these circumstances. But I also gave you to look at a case in the Illinois Supreme Court, People versus Relaford. Now, this could be a little bit confusing because you might say, wait, this is a state Supreme Court, not the U.S. Supreme Court. Why is it deciding this issue? Well, state courts, there are state crimes. If a crime is being prosecuted in state court, a defendant is entitled to assert a constitutional defense. That constitutional defense can be decided by the state courts. Now, from a state Supreme Court, it is possible to take an appeal to the U.S. Supreme Court by petition for certiorari, but most of those petitions are denied. So in this particular case, the U.S. Supreme Court did not take the appeal from the Illinois Supreme Court. What this means as a matter of precedent is that the interpretation of People v. Relaford of the First Amendment applies in Illinois, in the state of Illinois. It is not federal law. That's the way U.S. federalism works. A different state court might look at it differently. Ultimately, the U.S. Supreme Court might look at it differently. But at least in Illinois, this is the rule. And I'm giving you this case not so you know the rule in Illinois, but because of how the court is analyzing the question, how it points out some of the difficulties we have here. So Illinois has state stalking and cyber stalking statutes. And as you see when you read the case, they differ a little bit from the federal stalking statute. And the question is whether they violate the U.S. First Amendment and or the Illinois Constitution, which has its own free speech clause. So procedurally, the defendant is convicted of the cyber stalking crime and he's sentenced to 6 years in prison. Significant sentence. He appeals the conviction. An Illinois appellate court held the statute to be unconstitutional. So at this point, his conviction on this part of this crime is going to be overturned and he's going to be a free man. And the Illinois Supreme Court affirms the Illinois appellate court on this part of the case. So here are the facts of the case, and once again we are seeing a common fact pattern in cases like this. He applies for a job at a radio station, he doesn't get it, he is upset, he is showing up at the radio station, and then he's trying to make contact with an on-air personality. He's barred from the premises then of being on the radio station, and he has multiple really disgusting Facebook posts, which you can see in the opinion. The holding of the Illinois Supreme Court is that the Illinois cyber stalking statute is overly broad and unconstitutionally impinges on the freedom of speech. So why is that? Well, when you look at the Illinois statute, it is more specific than the federal statute that we looked at in the Alonis case on this question of mens rea, or at least it's interpreted more specifically by the Illinois Supreme Court. So remember, in the Alonis case, Justice Roberts says the federal stalking statute relates to the intent of the defendant, not the effect that it has on the victim. And that's important as a matter of sort of our criminalization principles, and it's important for whether we're going to be able to restrict speech. Here, the Illinois statute clearly says, this part of the statute we're looking at clearly says, what is the effect on the victim? Is it speech that a person knows or should know would cause a reasonable person to fear for their safety or suffer other emotional distress? This is a negligence standard. I'm just going to abbreviate because it's hard to write with my mouse. This is a negligence standard. And now, as we said, you could have a criminal statute that criminalizes negligence. But if you're going to criminalize negligence in the area of speech, that's going to be a potential First Amendment problem. And this court says, in this case, it is a First Amendment problem. This is a content-based restriction. It is restricting certain kinds of speech. That is subject to strict scrutiny. And the court agrees, of course, that, as it must, because this is law, that a true threat can be criminalized under First Amendment jurisprudence. But a true threat, that true threat doctrine, is not just negligence. What does true threat mean? True threat means something about the mens rea, something about the intent of the defendant. And if you look kind of policy-wise about how this Illinois statute, this negligence standard would apply, there are lots of kinds of speech in the brick and mortar world, but even more so in the online world, perhaps, that can cause some emotional distress. And that is part of the price we pay, this court says, for having these very broad and important free speech principles. It's not something the criminal law can or ought to address because of the First Amendment. All right, so we've gone now through a lot of our basic material. We've looked at the federal statutes. We've looked at some federal case law on mens rea in the Supreme Court and on the First Amendment challenge to the federal statutes in at least one intermediate federal court. There are others, by the way, but pretty much universally the federal appeals courts have upheld the federal stalking statute. There's a rare case or two where an as-applied challenge in a specific circumstance has succeeded. And we've seen a state court dealing with a state statute that is broader than the federal law, or interpreted more broadly to cover mere negligence as the mens rea, and saying that would violate the First Amendment. So here's our discussion question that I'm going to post in the forum, and I want you to talk about online this week. And this is, to me, a really difficult and interesting question because of the sensitive issues we're dealing with. So first piece of this, how aggressively should prosecutors enforce these existing laws? You know, these questions, these legal questions about mens rea and about the First Amendment, they surface this underlying question that we began to talk about last week of prosecutorial discretion. The laws on the books could be interpreted really broadly. It's certainly the case that if certain prosecutions were brought, like say an actual rapper is prosecuted for some misogynistic lyrics that maybe name a rival rapper and the rival rapper's girlfriend or something like that. If you have that kind of prosecution, then the First Amendment issues are really going to kind of blow up. And part of prosecutorial discretion is saying, we're not going to bring that case. That's not going to be a criminal case. It's a different kind of social problem maybe, but not for us to deal with. On the other hand, we do have these real problems of this toxic online culture. So how aggressive should prosecutors be here? Should we have additional laws relating to online harassment? Is the problem such that the existing stalking and harassment laws we have aren't enough to deal with it? And if we should have additional laws, what would you propose? How would you deal with these problems of mens rea and the First Amendment on the criminal side? Would you propose some other kind of civil law? I'll give you one example that we're not going to look at in detail, but New Jersey has a cyberbullying law that relates to the public schools, and other states have laws like that as well. So on the one hand, it's a serious problem, and we need some kind of law like that. But on the other hand, what it does is it requires school districts to have a disciplinary mechanism in place that is really burdensome and difficult for the school districts to administer. And then that runs into further problems because a lot of this bullying and harassment happens when kids are not in the school building. And they're not in the online classroom of the school, but they're raises other problems because a lot of this bullying and harassment happens not when kids are in the school building, not when they're in the online classroom, but when they're playing video games or in their Instagram feeds or in other places. So that's, you could have one aspect of this social problem be addressed, say, in the schools, but that's also raises difficult policy questions. So how do you think this ought to be addressed? That's what we'll discuss in the forums, and I look forward to seeing you online during the week.